You just can't seem to follow the rules.
She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. That's she control thing she's trying to do. That's it.
I don't care what it is.
Right out of the gate, the judge isn't just hearing excuses. He's spotting a pattern. In courtroom dynamics, repetition matters. When a defendant keeps blaming someone else, judges start shifting their mindset from maybe this is situational to this is behavioral. And that shift, it changes everything. Bond, sentencing, even credibility. Let me ask you, do you think this sounds like a one-time incident or a cycle?
You have got all of these charges.
I understand.
You just need to just stop blaming them.
Miles Carter.
Thank you. Mr. Burgess.
The PE is scheduled for tomorrow morning. I believe.
On the one case, I have a new case, however.
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client on those charges.
I am.
Okay.
And I don't know. We're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already.
It's a charge of interfering with electronic communication device, the 2-year felony. And then also domestic violence, second offense, the 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please.
Here's a critical legal moment most people miss. The defense is asking for a low bond or personal bond, but the prosecution is about to highlight something far more damaging: new charges while already on bond. That's a huge red flag in criminal law. It tells the judge one thing: prior conditions didn't work. If someone violates trust once, do you give them another chance or tighten control?
For November 14th, 2024 at 9 a.m., or as your invite indicates. As to bond in that case, you want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning or this afternoon. And obviously the court knows his history of appearance in front of this court. Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honors, indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's still on a tether, Your Honor. He did post a significant bond in the last case. Understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
Anything from the people?
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court.
Right out of the gate, the judge zeroes in on the real issue: accountability. In court, blame shifting isn't a defense. It's a red flag. When someone keeps pointing outward instead of inward, judges start thinking about risk, compliance, and whether future orders will be followed. If you were in that courtroom, what would you be focusing on? The excuses or the pattern?
First of all, this court arraigned defendant on not his newest felony.
This is where things get serious. The prosecutor is laying out a timeline that's devastating. First case, court order, no contact, then a new incident just days later. In legal terms, this isn't just another allegation. It's a potential bond violation layered on top of a new felony. At this point, what matters more? What actually happened, or the fact that contact happened at all?
It's just arraigned out, the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. So later, and I will tell the court after review of the police report, the person representing themselves to be the defendant did have contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but did admit to having contact with her. Now, because the defendant, because the police officer was speaking with the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person kept called him back, represented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the scope of probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation, revoke the probation, and sentence the defendant to serve balance at this time. And in bond in this case, we're asking for $100,000 for the new felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. Better, I'm not entirely sure what is going on with you in that regard. I ordered you on the 7th not to have contact with this person. And then, lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't, but
Right.
Let's break this down clearly. A no contact order is not flexible. It doesn't matter who started the conversation, who approached who, or what the intention was. Legally, the rule is simple. Zero contact means zero contact. And this is where many defendants fail. They argue context while the court looks strictly at compliance. Be honest. If someone approaches you first, should you still be held responsible for breaking the rule?
But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go.
Simpson, can I say something?
You can say whatever you want.
I understand. She put up on me. I was in the room playing my game.
This is the moment where legal reality collides with personal narrative. A no contact order isn't a suggestion, it's a bright red line. Even accidental or brief contact can count as a violation. Courts look at one question: did you stay away as ordered? Intent matters emotionally, but compliance matters legally. Do you think most people truly understand how strict these orders are?
In the room. And
Then you get up and leave.
tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car and that's when I pulled off.
Well, maybe that's all going to come out, Mr.
I understand.
Carter. Maybe that's all going to come out. I let you out the last time. Should have of all rights.
Now the judge is done negotiating. Listen to the tone shift. This is no longer about understanding. It's about consequences. When a judge says, "I gave you a break," that's courtroom language for "you used up your last chance." At this stage, the decision is no longer emotional, it's procedural. Do you think the judge already decided the outcome right here?
Locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? You get that other case set for exam. Then what ends up happening? I get here and you've got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety. On his other matter, anything you want to say before I post sentence on that case?
I want to say, I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. You understand it. When I get out this situation this time, I'm gonna be by myself.
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on a $100,000 cash bond, and you're about to go now.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks.
And here's the final blow. The judge revokes probation and imposes jail time, not just because of the new charges, but because of a pattern of non-compliance. This is a textbook example of how courts escalate. First chance, warning. Second chance, strict conditions. Third failure, custody. And notice something powerful. The judge shifts from legal language to personal accountability. Stop blaming them. So what do you think? Was this outcome inevitable, or could one different decision have changed everything?
Keep doing everything, and he keeps just coming back to this court, disappointing this court, and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm going to revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. Defendant is to serve the balance.
Your Honor, the court ordered the Dawn Farm program. Probation also requested the DV program. So if you just requested DV, the court want the defendant to perform both or just one or the other?
I should have said in-jail DV program is what I meant to say. Thank you.
Okay.